So, my name is Raphael. I'm the managing director and one of the co-founders of User Rights. And User Rights is one of the first out-of-court dispute settlement bodies which was certified under Article 21 of the Digital Services Act this summer. And I'm going to be speaking about the first steps and challenges we experienced and we still are experiencing. What does user rights do? The Digital Services Act covers many online platforms. We are focusing on social media and think basically the space is big enough for us, and we only have the expertise within these special and certain topics. We were certified EU-wide for pretty much all content moderation measures. And I'm always trying to make examples of two different constellations, which we basically cover. The first one is if a person posts something online on a social media platform, and basically this content gets deleted, it gets blocked, it gets demoted, it gets shadow banned. Basically, no one can see it anymore, or it's gone. These persons can come to us and basically appeal the decision without having to go through the internal appeal mechanism of the specific platform. The second constellation is pretty much the notifying constellation, that you see something potentially illegal, potentially harmful, or against the terms of services. You click on report, and the platform then decides to not act. In this situation, we basically decide if the platform would have had to act after being notified. Our certification covers illegal content in Germany, but just some specific rules and the terms of services of the platforms, but only in a specific scope too. We chose to do pretty much all the harmful content which is not graphically violent or covers kids or IP and data protection. So we basically do defamation, insults, we do sedition, we do all crimes against the state, we do crimes against democracy, and we pretty much do all crimes which have to do something with illegal or harmful speech. We are certified for German and English. So basically most cases right now are being brought to us in German, and within German, it's like 80 to 90% covering terms and services. The rest is potentially illegal content. As I mentioned, our focus is social media, and it was very important to us to not have to do all social media platforms at the beginning. I'm going to come to the complexity behind it at a later stage. But we chose to start with TikTok, Instagram, and LinkedIn because we had the idea and the feeling that it covers most social media platforms, like the variety of platforms. And it's the big platform. So basically, we need to try to implement processes, discussions, and communication about actually how to do what we do and to learn and find out with the platforms and how to do it together. On the right side of my slide, you see Article 21, and European law is always a bit more extensive than German law, but that was pretty much what we started with, reading the law and trying to find out what dispute settlement within the Digital Services Act means and how we can try to offer what we're offering now. As I mentioned, we were certified in summer, August 12th, by the German DSC after basically having a continuous dialogue for more than a year. I first wrote a few questions to the German DSC in March last year. And there were so many unknowns and so much discussion with the German DSC, with the Irish DSC, with the European Commission that basically was like a step-by-step process, which ended up in 42 documents we needed to draft for the certification process, which covered pretty much everything. We needed to show expertise, impartiality, independence. We needed to prove how we want to do the settlement procedure, because there's so many different options which are not being defined in the law. What's the kind of settlement procedure? Is it mediation? Is it more arbitration? Is it potentially reconciliation? Is it like a legal analysis in a normative framework, like Germans typically do it in a constitutional court? Is it something new which needs to be found out by us, basically? And we came to the conclusion that we had the sense that it's only going to work with a normative framework very similar to court cases in civil law in Germany. So basically, we have tried to implement a very efficient system. So users can come to us online, type out or fill in a form, send out the data digitally to us, and then we try to, well, first we give legal hearing to both parties, and then we try within this framework to make a legally sound and good quality judgment between the parties. And the idea is to create a decision which looks very similar and basically has the same format and the same language as a typical court case. What did we need to do else in the certification? So pretty much a lot of our work was business planning and financing. The fees, I'm going to speak about the fees in a bit, but the fees weren't defined and the fees need to be reasonable. So basically we can charge more than we spend as a out-of-court dispute settlement bodies. The costs may not be higher than the costs incurred by the body. So it was kind of like tough trying to figure out what we can charge, what different complexities there could potentially be, what's pretty much the percentage of cases being brought to us, how many are easy, how many are simple, how many are super complex, how many of them will need basically a fundamental rights weighing. So many unknowns. But we tried pretty much with the dialogue and the conversation to have a sound and a true, valid and a fair system between the two parties, with a lot of understanding for what the platforms do, but also a lot of understanding what the users and organizations which come to us actually want. We needed to prove our language requirements. That was one of the things which were quite unclear. So if I want to decide cases in English, how good does my English need to be? And if I want to decide cases in French, is it good enough to speak French? Or do I need to know something about French law and the specifics of French law? So pretty much we always had a differentiation between terms of services and the legal content. And as I said, in terms of services, we do have the feeling that the fundamental rights and the normative framework within decision-making of terms of services is harmonized in Europe. So we have the same standards when we decide about appeals from Europe in Germany, in France, in Hungary, and in Poland. We had to start with all types of cases. I'm going to come to the complexity and the difficulties later. But we saw in the past few months, by now it's 4 certified out-of-court dispute settlement bodies, that the discussion isn't harmonized yet. Like for us, one big difficulty was that we always knew that we were going to be one of the first organizations. And we knew basically that a lot of conversation with the platforms about the technical requirements, about the data exchange need to be done. Yet the German DSC basically made us take cases on the first day of certification without knowing anything, without having talked to the platform, because they basically said, you can come to us once you're certified. It was quite clear for us that it's going to be quite challenging to start right away and to basically require the platforms to work with us in good faith and to provide the data we need to decide. So many things needed to be cleared up, yet they ended up in a certification on August 12th. We got cases on day 1, and by now we got about 300 cases and made the first decisions. So what do? We do a comprehensive review of various rights, especially of fundamental rights. Article 14.4 is one of the biggest challenges, that platforms need to respect the fundamental rights of its users. What does it mean for us? It's like a big discussion within academic circles. We just met 2 days ago in London with all the platforms and other ODS bodies, and no one knows basically what to do with fundamental rights, and especially not in the ODS bodies. When do we need to weigh in fundamental rights? Is an easy, simple insult something which we need to consider within the freedom of speech? Do I need to check opposing rights if you insult a politician, for example? So many unknowns. I'm going to come to it later. It's part of the reason why we founded a academic advisory board with 4 young professors from Europe to basically discuss and to answer these questions which we need answered to find our role and to do what we're supposed to do. One other big thing in the certification process was basically proving our independence and their impartiality. We need to be independent from platforms. We can't be financed by them. We need to be independent from trusted flaggers. And we need the appearance of being impartial and independent. Otherwise, it won't work. But what does independent mean? What does impartial mean? How can we finance ourselves? Who can we take money from? Is it something we have to do ourselves? Is it something investors could jump in? So many unknowns, yet we always had the conclusion and the feeling that it's nothing like a typical startup context. We can't take money from any VC investors. We can't take money from big banks. We need to do it somehow by ourselves to prove the people and the platforms that we remain independent and impartial. We only can charge reasonable fees. So basically the business model behind it is kind of complicated too. We don't know when the platforms are paying. We don't know if the platforms are paying. So here too, we do have many unknowns. Yet one of the things I found most interesting and honestly most strange is the unilateral cost-bearing obligation. So basically, Article 21 says that the platforms have to pay no matter what. So if you insult a person on Twitter, for example, and this post gets deleted, you can come to us and we say, basically, you said something illegal, something harmful. It could actually be prosecuted under German law. Twitter did everything all right, we can still charge the platform. So basically one big discussion is what's reasonable and how to prevent abuse and what's our purpose. Are we there for every person who can come? Is it, what do we do if it's like definitive? In a sense that this person does something basically just to make the platform pay. So with this one-sided fee arrangement comes a big complexity that we need to prevent abuse. And we need to somehow find a way of preventing abuse. Article 21 says that we could charge a nominal fee, and 2 other of these bodies chose to basically charge a nominal fee. The Irish do €5, the Hungarian settlement body does €10. We have the feeling that even like a nominal fee of €5 is way too high to basically implement the sense of the law, and it will be too much for people to actually come. So we decided not to charge a nominal fee, yet not charging a nominal fee requires many processes of basically finding out what happened. Is it within our scope? Is it something abusive? Is it someone who basically just wants the platforms to pay? So big problem, basically screening for eligibility. Is it CSAM? Is it IP law? Is it copyright law? Is it data protection, which falls outside our scope? And if something falls outside the scope, is it something we can charge the platforms for? Is it something we want to charge the platforms for? So basically, one-sided fee arrangement without a nominal fee requires many technical and manual processes to prevent abuse and to basically allow the system to work. Article 21 also says that there is a good faith cooperation requirement between the body and the platform. Yet good faith is not being defined. What does good faith mean? And when is good faith basically the argument, and when is like a legally sound model the argument? My rules of procedure, basically, do they have like a legal context and a legal justification? And do my rules of procedure bind the platform? So if I say my deadlines are 7 days, is it binding for the platform? Or is good faith basically communication in that sense too? What else do we have to do? We have to report to the German DSC and the Commission at least once a year. And that's why we chose a very technical, a very efficient, and a very database process. But we'll be speaking about like what we do and how we do it in a technical sense a bit later. So how do we strive to do it? We want to provide, as I mentioned before, very high quality and comprehensible decisions. For me personally, it was very interesting having worked on basically trying to found Article 21 without knowing what will be brought to us. Is it basically right-wing COVID deniers? Is it left-wing activists? Does it make a big difference between notifying and potential active measures against you? And we see at the start that basically everything comes. So we have like people on the very right wing who don't believe in COVID and don't think that immunization could be something good. We have left-wing activists basically fighting them. So everything happens in social media, and we see that everything is basically being brought to us. As I said, we do a data-driven analysis, because data-driven analysis is the only thing in the context of Article 21 which allows us to report with basically good numbers, with bulletproof numbers to the German DSC, and to provide maybe analysis and reporting for the systemic risk assessment of Article 34 and 35. For us, it was very important to basically have the expertise. We not only needed the expertise to prove in the certification process, we had the feeling that we need expertise in like many different legal fields to be able to potentially allow the working and the functioning of Article 21. So we're three co-founders. One of them is Stefan Breidenbach. He's a professor and has been a professor of mediation and civil law for more than 30 years. And Stefan is basically the expert in mass claim management. He founded his own companies, and he did like they founded a company which basically allows, within the diesel scandal in Germany, to file mass claims and to build tools for big law firms to make this much more efficiently. And since we don't know how many cases will come, but expect a great number of cases, it was clear that we need the processes, we need the security, we need some kind of like data protection and expertise within handling these kinds of cases. We then need expertise in European fundamental rights. Is it being harmonized? What kind of fundamental rights do we look at? Is it Article 5 of the German fundamental rights, Grundgesetz, or is it Article 11 of the European, the freedom of speech? So my other co-founder is doing his postdoc in Oxford. He is basically the expert in European law. And I've been a lawyer for 5 years, and I've always worked in like tech startups and digitalization of the law. And us three come together with a different expertise to be able to potentially allow these good quality judgments in like very different manners and very different situations. And as I mentioned, we also founded an academic advisory board, basically to help us. It's independent, it's impartial, but to help us answer and ask these questions. What to do with fundamental rights? What to do with missing statement of reasons? What is our role? What is the role of the German DSC? What's the role of the Irish DSC, or potentially other DSCs? What's the role of the Commission? What's the role of bodies? What do we basically strive for in the European context? We do now have bi-monthly meetings, and we plan on publishing a bi-monthly discussion report too. We just published the second one yesterday, and the second one is about fundamental rights. The first one is about the statement of reasons. And if you're interested, very happy about your email, but you can also find it online on our homepage. What are our challenges? Good faith is not being defined, and for us it was always clear that we need the data exchange and cooperation with the platform to be able to decide. Example A was that you post something which gets deleted, and you might not have the content. We need to look at the content to basically weigh in, was it justified or was it not justified? So for us, one big challenge basically was we need the content. How do we get the content? And how do we ask the platform of providing the content, and which system is going to be used? Am I going to send an email to Meta basically saying, hi, this is Raphael, please send me the data of username X on date Y? Or is it more technical system? And if it's a technical system, who's building this technical system? Is it us as ODS bodies? Is it the platforms? And if basically both parties build a system, what does good faith mean in that sense? Who's going to use which system? One big question, which I always found very interesting in the certification process, that I had the feeling that data protection and information security were not thought about too much in passing the law and in basically trying to implement Article 21. So my fear was always that once we get certified, we write, just for example, Meta an email and say, we got our first case, please send us the relevant data. And then Meta is going to say, okay, where's your data protection clause? Where's like the signatures when in the data transfer agreement? And can you please sign the supplier terms here? Pretty much. It was clear that data protection and information security, in a sense of cases which are very intimate, which are very public in sometimes, but also have like a result which could potentially show that you actually committed a crime. So we do have a high respect for and high understanding of the sense that platforms are very careful in sharing data and sharing specific data. This is something which needs to be talked about, and this is something which needs European guidance because it's still being debated about pretty much. Also, the scope of certification. As I mentioned, we started, let's do like the bigger cases with Instagram and TikTok. Instagram has like very different terms of services than TikTok. And we basically had the big problem that within certification, there was a huge guideline being published by different DSCs. And the guidelines pretty much try to show the scope of certification and try to narrow down the potential headlines, basically. So we have unsafe products. What does unsafe products cover? Is it weapons? Is it drugs? Is it basically selling products without the European regulation? But to make it a bit more complicated, where does spam fall under? Spam is not being mentioned in the guidelines. Integrity and authenticity is not being mentioned. Is spam even something which could be moderated and could be appealed? Is it a content moderation decision? What happens if like different cases of spam come to us? There's potentially someone who posts the same thing 10 times a day, but there could be a Russian coordinated bot attack. Is this something we need to check? And if it's something we need to check, how do we check it? It's not like a legal analysis. This is more like a technical analysis and proving IPs and basically trying to find out what happened on the technical side. Our solution is basically trying to find best practices with other ODS bodies and to try to make the DSCs and the Commission set standards. For us, it was very unfair in a competitive sense too, in many ways. Like we had to start taking cases right away. Other certified bodies got their certification and could wait for 3 months, going into a dialogue, going into negotiations with the platforms to be able to then start right away. We had to start taking cases, and now basically it took us 2 months to get the good faith in a sense that it's actually working. It took us 2 months basically to get the data, the relevant data from the platform. And I had to basically tell our complainants for the last 2 months, we're so sorry, we're trying our best, yet we can't enforce any more speed here, and sorry, we'll get back to you, basically. So what would be very nice, very helpful is coherent guidelines, and coherent guidelines are needed in a European sense. The user, the organization, the person always gets to pick the ODS body, and the user somehow needs to rely on a specific and coherent guideline and needs to know that there's some way of basically trying to differentiate the quality and the system and what other ODS bodies offer. How do we how do we solve cases and how do we work? As I mentioned, we have like very much experience with mass claim management and with like the digitalization of the law. And since Article 21 requires us to be efficient and swift and cost effective and to have reasonable costs, which are supposed to be less than a similar court case, Our whole system is being built digitally. So if you go to our homepage, you can fill out a form, you can upload a few screenshots of the notification or this statement of reasons. We then do a AI-supported pre-check. The pre-check, and that's another specialty when you do legal content, the pre-check in Germany, at least under the definition of the DSC, needs to be done by a lawyer with a bar exam. We need to recognize, does it fall within our scope? Is there potentially other illegal content from a different country in the European Union, which we are not certified for? We don't have the expertise. What do we do with spam? What do we do with integrity and authenticity? We need to screen, we need to prevent abuse, we need to check if it's actually eligible. And if it's eligible, we need the legal hearing of the parties. So basically, we send out the case to the platform, ask them to provide context, to provide the necessary data, then go back to the complainant, send out everything the platform said, like a real court case. And then once we have everything to decide, our decision maker will make an independent and impartial decision, send it out to the parties, report in our database, and once a year we report to the German DSC. I'm going to go quickly through this, but the magic behind what we do is basically an invention of my co-founder, Stefan Breidenbach, the professor, and he invented a special visualization of the law. It's called rule map. And the rule map is basically like a forest structure, which like the tech-savvy people might have seen before. Like once you build a chatbot, for example, it's going to look exactly like this. Yet the big difference is that the connections of the rule map are being set by the standards of the law. So we have different connections, and the different connections here are basically the rules and the options and the possibilities the law or any rule, any policy provides. So we have the and connection, we have an and or connection, we have an exclusive or connection. And for the lawyers listening, you might see that this visualization provides us with the option of visualizing the law and putting norms in the structure, which basically the law provides us to. Don't want to go too deep into technology here, but that's then what we do. Every one of these nodes can be filled by the knowledge we have. It can be connected to a database we have. It can be connected to AI tools. So we try to automate the process management as much as possible. But the biggest challenge for us basically is putting the human in the loop in a context to be able to make good decisions, yet to be also able to make independent and impartial decisions. So we take great care of basically building these trees as the law says, as the terms of services provides us to. So for every platform, we're going to have an own tree, which we call them. And this tree is and will be structured by the definition of the law or by the definition of the terms of services of the platform. So what is being done then? Basically, the connection of the different clauses of the law, of the different rules, and a visualization of every potential aspect which we need to cover. This is being calculated. This is being done by hand too. So the human in the loop, which is always a lawyer, will check every step, can make his own decision, but the decision will be much more advanced if there is the possibility of getting additional information, of seeing the database in relevant context or similar decisions, for example. And to show you one more example, that's one of the cases being brought to us. And it's an Instagram profile. And in the description of the name, the user said, Alles für Deutschland. Alles für Deutschland is from the Nazi party back in the 40s. It's actually something you can't say in Germany. It's a crime. One big question for us was, is this content or is it just a description of the name of the user? And is it a content moderation action? Basically, if it's within the description of the name, or is it something which needs to be posted? But this case, one example, we need to check for potential illegality. And that's actually a screenshot of the trees and the rule maps we built internally. And if I let this screenshot run through our system, I do have a good sense of what happened, actually. And for the German laws, you can see here that paragraph 86a of the German penal code is fulfilled, and that's something you can say. So a crime has been committed, you see it's green, and green meaning this crime is being fulfilled, basically. What are our next steps? As today, we need dialogue with regulators, we need dialogue with civil society, other ODS bodies and platforms. Within the next 2 years, we will have to do all social media platforms. It's actually right in our certification. Also, internally, we want to extend our scope. We want to do more areas of expertise, maybe copyright law, maybe data protection law. As mentioned, we have to do all platforms. We are planning on giving access to more languages and countries. And very happy about your feedback. And thank you so much for your time.